Hi, I'm Tulsa divorce attorney Palmer Johnson, and welcome to my video series where I discuss frequently asked questions I get from my family law clients. And today's question is, what should be in a valid prenuptial agreement? And there's not necessarily a right or wrong answer to this question, but there are some kind of key things that are important in forming a valid prenuptial agreement, and that's what I'm going to talk to today. So there should first and foremost be a full disclosure of all the assets and liabilities of both parties at the time that the agreement is executed. If you're going to give something away, then you need to be fully aware of what it is. So if, in other words, you can't forget to tell the other spouse, or they can't forget to tell you about the $5 million of stock that they have in Apple at the time that they ask you to disclaim your interest in that stock. It's typically recommended that both parties would have independent legal counsel. That really helps ensure the enforceability of these agreements later. Again, it's not necessarily a requirement, but it's going to absolutely be helpful if someone tries to attack the validity of the agreement at a later date. So these are best practices. Um, so along with the disclosure of assets, the agreement should not be so unfair or one-sided on its face that it would kind of be suspect if anybody read it. If you have an estate that's currently worth $10 million and the agreement provides that your spouse gets just what they came into the marriage with, and perhaps they have no significant assets of any consequence. Maybe they own a car that's worth $10,000, and it says, well, they can have their $10,000 car or the equivalent of that, but everything else they would just depart the marriage with. Well, that's probably going to be problematic. You know, again, you're looking at contract formation here, so. Is it possible that you could have a scenario where there was enough disclosure? Again, I think that there has to be some fairness, and or there would have to be some additional upside for the other person. In other words, um, you're simply disclaiming the value of your assets coming into the marriage, but anything that could be considered marital would still be divided. Now that might be a different story. So it just depends on exactly how the parties intend to approach it. And like all contracts, each one's going to be interpreted and based on what the actual document says. But there are some things that the courts have said that can be looked at in how you interpret the intent of the parties. And one of those things would be the behavior of the parties during the marriage. Um, Perhaps the parties take certain actions that would be indicative of how they interpreted the actual agreement and what they interpreted any vague or ambiguous provisions of the agreement to mean. And the court might use that to aid their interpretation of the intent of the parties. But really, they're going to look at the four corners of the document as the tipping off point. And so what you want is a really straightforward, clear-cut agreement um, that's going to provide what you do in the event of a divorce. And it's going to talk about who gets what you came in with, if there's going to be certain things that are valued, how are they going to be valued, if there's a specific cash provision for another party based on the years of the marriage. All of those things should be included and very clearly laid out in the document itself. And that way you can avoid the attack later of fraud for failure to disclose or duress, um, which would have to do with how you ask the circumstances under which you obtain the signature or agreement of the other party. And the biggest thing I can tell people is you absolutely don't want to put this document in front of someone and say, if you don't sign this, then we're not getting married. Although that can be a little counterintuitive because it very well could be a requirement of one of the parties to actually enter into the matrimonial relationship. Um, it it doesn't need to be held over the other person's head in that way. And if it is stated, it just simply needs to be done so in a very matter-of-fact way and not in a threatening way. So if you are thinking about getting married and entering into a premarital or prenuptial agreement, and you've got questions about your own specific situation and how to best protect your assets, please reach out to me at moms.law, where you can set up a low-cost consultation where I can specifically talk to you about your circumstances and how to best protect your assets and your family's future.